Well, I'm the sole lawyer today, and there is a lot to say about big data and law. And for me, as a lawyer, it's very interesting to be here, to listen to you and how you deal with big data. And what I realize is that you're not really using law in the construction of your big data strategy. It's more a stage to go to because you have to do it, but that's all. And you do the less you have to do, but that's all. It's not a point that you take into account to build this strategy. And very often it's only, this little sentence at the end of a slide, like, we are going to comply to all applicable law, blah, blah, blah. And very often the answer is, we are not ready to comply all the law. And that's exactly what I want to talk to you about today. I'm not going to talk about intellectual property or GDPR, but how you can use the law to build a very good big data strategy and why it is important to use the law to build this strategy. So, as said during the past 2 days, data control has become a key competitive issue for all economic actors. The implementation of a data analysis strategy aims to be more innovative to achieve a high level of customer satisfaction. In the cultural field, big data brings new perspective for the dissemination of cultural works, and you are using a lot of visitor data. Visitor data analysis allows cultural institutions to better understand their audiences and to offer them a diversified and personalized offer so that visitors become actors in their visiting experience. And for you, I think it's very important. For the first time, culture is at the heart of a new ecosystem, that is the production and the dissemination of personal data. And in this context, you have to answer this question, how to set up such a data analysis policy. If we take a closer look to the visitors' data collected by museums, we see that they collect a huge amount of data, whether it is data from ticketing, loyalty programs, interactive visit feature, or social networks. These data are most of the time locked in silos and are not exploited. The challenge for you is to identify the qualitative properties of each field and pool them, because the value of the information does not come from the data itself, but from the cross-checking of data between them. And this is exactly what faces a major legal difficulty. Big data revolution is confronted with the implementation of numerous and complex legal rules, and especially laws on protection of data, personal data. Their purpose is to regulate the collection and processing of personal data so that the data subject retains control of his data and his private life. These laws were mostly developed in all the world in the early 70s with the appearance of computer. But the advent of the social network for the past 10 years has made these laws obsolete because of a very international environment and an overconsumption of data, especially by the GAFAM. You all know what is GAFAM, I guess, yeah? But we face today a real paradox. Each individual leaves a trace of himself at each of his actions, whether he likes a photo on Facebook or when he passes a security check at the airport. He is an accomplice in the dissemination of his data, but in the same time, he is more and more suspicious of the digital environment. The protection of the personal data in this context is a very big challenge for lawyers. Faced with a wild collection of data by more and more actors, many countries wish to strengthen data protection to counter the negative effects of big data. The objective is to promote a reasoned and transparent system of collection of personal data. The GDPR illustrates this move by reinforcing the obligations imposed on economic actors in terms of data collection and the penalty incurs. All European countries, all European companies or foreign companies processing data related to the European territory are now subject to a very strict regime to guarantee they ensure optimal data protection at all times. The system is based on the following principle: transparency. The person must know that his data are collected, for what purposes, under which condition, and to whom they are transmitted, and most of all, the person must be able to refuse the treatment of his data when it is not necessary. Second is trust. The data controller must ensure that the data collected is strictly necessary to achieve the purpose for which they are collected, and that it is qualitatively exploitable. That's what we call the minimization principle. And it processes the data under technical conditions to prevent any security breach. That's the privacy by design. And third is accountability. It is the obligation for companies to implement internal mechanisms and procedures to prove compliance with data protection rules. The implementation of the GDPR has caused a disruption in many companies. On a global scale, some see the GDPR as a loss of competitiveness for companies, and this mostly for two reasons. Companies must invest heavily in the protection of personal data, which is dissuasive for the implementation of a big data policy. And second, this regulation seems to oppose the very foundation of big data, which is the massive data collection and the predictive analysis that is directly opposed to the principle of minimization and primary control of the individual on his private life. Regulation on data protection thus becomes a brake on innovation and is experienced as a huge constraint for companies. This way of considering the law is in fact very reductive and disregards, on the one hand, the primary role of the law, which is to give the various actors a tool allowing them to secure their legal relations, and on the other hand, the meaning of big data. As we said earlier, the development of big data places the individual and the customer experience at the center of the strategy of the actors. The construction of a big data strategy must therefore be done not only based on what we want to obtain at all costs, but according to what the customer expects from the service provider. The law, it's mine. Yeah, thank you. The law is always a good indicator of the state of a society, and all the regulation adopted in recent months around the world shows that consumers want more transparency and ethics. Developing an effective big data strategy means understanding the expectation of your target and integrating them into your strategy. It appears that the companies that make their compliance with the GDPR a full value proposition have gained a very important competitive advantage. People will more easily accept to authorize them to collect and analyze their data if they trust it will be done to their benefit and in an ethical way. Thus, the establishment of technical and internal measures to ensure the ethical use of data and compliance to the law appears to be the backbone of any long-term successful big data strategy. And that's my second question: how to provide such guarantee to the customers as well as to the different actors involved in the implementation of a big data strategy? Is it or not the role of the legislator to determine the appropriate measures for the ethical development of big data? I guess the answer is no, for at least two reasons. First, because the primary purpose of regulation is to provide a framework beyond which behavior is considered antisocial. By nature, the law is meant to manage the abstract and disembodied situation. It is not intended to manage particularism. In this sense, law is not flexible and is not meant to be. But each company wishing to set up a development strategy based on big data pursues its own objectives with its own resources according to its field of activity and use. And more, the law aspires to stability, which justifies that its evolution is very slow and very framed. Second, big data is fundamentally based on the idea of collaboration. Collaboration between the user who agreed to communicate his data and the company that wants to analyze it. Collaboration between the latter and the partner which will provide the necessary tools to analyze data and build a high-value offering. And finally, collaboration between the different partners on a project, each holding identical or different data, sometimes pursuing opposite interests, but whose interconnection would ensure better result of the analysis of the raw data. So it appears that the most suitable system for implementing a big data strategy is the definition of a data governance, whether at the level of the sole company or in a network of data partners. And it must be clear that I do not speak of technical management of the data, but a governance in the sense of distribution of powers between the different actors. Governance is understood as a framework for supervising behavior carried out according to predefined models by the actors who submit to it. These models determine who can perform which action, with what information, when, in which context, and with what method. It is a set of procedures aimed at governing and organizing the access and use of data in a way that respects the right of data subject. The approach of governance is pluralistic and interactive to collective action. Unlike the law, it does not come from an authority vested with a single power of decision, empowered to take obligatory comments. It presupposes taking into account the existence of autonomous actors pursuing distinct and sometimes opposing interests, the aim of which is to obtain cooperation. Governance is thus characterized by acknowledging the complexity of each situation and the existence of multiple powers to reach compromise acceptable through negotiation. But to be effective and to achieve the objective pursued, governance is necessarily based on the use of legal tools. Governance needs law because it provides a stable framework for the rules of play and interaction. The goal is to rule negotiation in good conditions and to reach a compromise that cannot be reversed. In this context, contracting is a privileged tool for formalizing governance because it gives a frame to the discussion and because an agreement is considered as the law between the parties. The obligations parties have chosen to submit to become obligatory commands as strong as if they were imposed by the law. The existence of a contractual framework has the effect of stabilizing and sustaining the system of relation between the various actors concerned. So the contractual technique makes it possible to specify the commitments and responsibilities of each other. It serves to coordinate legally autonomous entities. Legitimacy comes from consensus. It forces each actor to take into account the preferences and prohibitions of the partners. In this sense, the contract becomes the continuity of the law, since contracting gives the economic actors a new take on the production of the law by putting the accent on the collective bargaining. And that's my sole slide. I will take a case use to explain you what can be the role of a lawyer to help you to build this governance strategy. So I'm sorry it's in French, I don't have it in English, but I will tell you what it is. It is a mobility project based in Saclay. It's a small town just near Paris, and it is called Move It in Saclay. Saclay is a business campus in which you have a university, a research lab, and industry, and it's a high pole of competitivity for technology in France. And so there is a lot of people working in this business center. And the sole problem of this place is that Saclay is in the middle of the field, surrounded by cows, and there is nothing around, not even a train station. So how to go there? You use your car. It means that every single person is taking his car to go to Saclay. So you've got 10,000 people working, 10,000 cars coming every day. So it is not very ecologic, for sure, but it is a big problem because of traffic jam. It is a part of France where you've got the biggest traffic jam in all the country. So the territory decided to build a platform to deal with this problem and to regulate the traffic jam. So in the center in green, there is a territory, Saclay territory. And it decided to make a partnership with Nokia to develop this platform. Why? Because the territory has not the skill to develop himself the platform. It has not the skill, it has not the knowledge. Nokia said, I have the knowledge, I can help you, but I just have the technical knowledge. I don't have the algorithm. Yes. Algorithm. So we're going to work with local university which has the knowledge and which need to test their algorithm in real situations. So they will be interested in joining the project. But the center of the project, he's in blue over there, it is the citizen, the people who is using his car every day. The territory needs the data so that he will know how many cars you've got every day in the same time and why there is traffic jam at 2 o'clock or at 8 o'clock, you know. But to get this data, he needs the citizenship to accept to give his data. And the question is, why the citizen will give you his data? You need to have incentive. If you don't have incentive, he won't give you the data and he won't use the platform, so you won't get the data. And the territory decided to say, we're going to have partnership with provider of service and provider of mobility service, like scooter, like free cars, or like, how you say that, sharing cars, and service of sharing cars. So we're going to propose to those providers a partnership. We're going to propose their services to the citizen through the platform so that they have an interest to propose a service to the platform, to the citizen. And the citizen will accept to give that data because they're going to access a very easy services which is adapted to their own situation. And the algorithm is going to analyze the data to propose to them the best service they can, depending on their own situation. So you've got exactly 4 groups of people around the territory. And they don't have the same interest in the project. If we take about the citizen, he has no interest in the project except to gain the services. And he doesn't want to pay to get it, okay? So he's going to have, but he wants to be sure that his data are going to be used only for the project and only for his benefit. So what are we going to do? We're going to have a contract which is called unilateral agreement. It means that the territory is going to take commitment in the benefit of the citizen, but the citizen is not going to take back some commitment. And I'm going to take commitment as a territory that I will respect GDPR, I won't use their data for any other thing, and if I communicate this data to other people, he will know it and it will be in a very secure way. And this is important. It is not just an ethical code or a simple commitment. It is contractual commitment. If the territory break its commitment, you can go in before a court and ask for reparation, for section. After, we have to deal with all the relation between the other partners. They don't have the same interest in this project. The territory is the most important one, and Nokia is the second one, because it is his platform, it is his project at the beginning. So they're going to be, both of them, the leader of the project, and they're going to have the most power. They're going to be those who decide who can access the data, where are the data, and how we're going to secure the data. But between Nokia and the territory has no skill to implement technical measures. So we're going to have an agreement just between Nokia and the platform to say Nokia is responsible for all the security measures on the platform. The territory could never see his liability engaged because of security breach, okay? And it is only the responsibility of Nokia. If someone, a citizen, for example, tries to engage the responsibility of the territory will immediately oppose his contract to the citizen and say, go and see Nokia. So this is an agreement between just Nokia and the platform. And then between the platform, Nokia, the research lab, and the service provider, you're going to have a mutual agreement. In this mutual agreement, which can be called consortium agreement, I think we're using this term in all the world, we're going to say we have 2 leaders, the platform and Nokia. And those leaders will decide who has the ability to access the data, and who can access the data to do what and when. And so we're going to make distinction. We're going to say to the service provider, we don't need to access personal data. So the data will be put in a bank and you won't access those data. The only data you can access will be analyzed data. So you won't have to respect GDPR because you won't have those personal data. And GDPR will be, we will be more compliant to GDPR because few people will access those personal data. And you will only use those data to give some services, to provide some services to the citizen and for no other use. You won't exploit those data for economic reason. It's only in the context of this project. And that's all. Why it is so strict? Because the provider have no interest in the project. They just want to be able to have this data to improve their own business for themselves. So they have no general interest. And the research lab, they really need to access the personal data. Why? Because they are building the algorithm and they are testing the algorithm to improve the platform and the services. So they will only access to the personal data and they will produce the improved data. But they need not to use this data for anything else. So they're going to have to take commitment of confidentiality and security. And what you can see is that it's a very complex agreement that we have built because you've got several levels of interaction between the partners and there is several levels of commitment. And you can deal with all those levels in just one agreement. So we've got what we call a pact, so the unilateral commitment to the citizen. So the citizen is sure you're going to be GDPR compliant. Then we have bilateral agreement between the platform and Nokia, between the platform and the research lab, between the platform and the provider. And then we have a mutual agreement, which is a consortium agreement, to organize the governance of the data. And that's how you can use the law to build a strategy that will protect your interest, the interest of all the partners, the GDPR, you will be in compliance with the law, and it will be a gain for everybody, because it's compliance with general interest we are looking for today. So this is the best way now to organize and to deal with big data project, because in fact it is the law that will allow you to have this kind of organization without any risk and to improve the organization of a good big data strategy. Thank you.